Okay, I would like to welcome everybody to the part three of our three-part webinar series on behalf of the Downtown Business Association. My name is Chris Aiken, I'm the chair, and the topic today is the office, how to safely reopen. I want to initially give a big thank you to our sponsor, it's Jodor Cafe on Del Mar, a terrific new addition to Del Mar. Please go support them. And without further ado, I'd like to introduce our speakers, who I'm sure you guys, some are familiar with. First, I'd like to introduce Javier Carbone. Javier is a San Clemente-based employment law attorney and workplace investigator. And I also like to welcome Shannon Wolf. Shannon Wolf is an employment law attorney based in San Clemente. She advises and represents small and medium-sized businesses in employment matters. Just a quick housekeeping matter. Speakers certainly encourage your questions. I will be monitoring the chat box. If you have a question, please feel free to do so. And I'll also share some materials as well through a Dropbox link shortly. But without further ado, to do our seminar on the office, how to safely reopen, I'd like to welcome Javier and Shannon. Thank you guys for joining us.
Thank you.
Thank you. So Chris, I know that you're going to share the link on the chat box, and that is going to be helpful to get the materials because we have resources for you to use. But I want to frame this conversation that we're going to have in the next hour or so in the sense of legal risk management, because the reality is that we have more than 1 hour of material. So what we're trying to do is to condense as much as possible so you get the information that you need to know to reopen an office workspace. And I want to frame first the dialogue and conversation that we're going to have today in 2 or 3 main areas. The first one is the health and safety concerns that are related to reopening. The second are the equal employment opportunities or discrimination concerns related to reopening. And last, the wage and hour liability issues related to reopening. And going back to the health and safety, there are 2 areas of concern on legal risk. And as attorneys, we think in legal risk management. So the first is, as a business owner, as an office-based business owner, do you have a legal risk concerning the public, the clients, the customers, that people that walk into your office? And the answer is maybe. But I want to say that the liability that is based on people who are members of the public is less than the liability that you have towards your employees. And what I mean by that is that the legal standard in general terms is that for customers, you will be liable if you're negligent. And that means that if you fail to do something that you could have done, or if you are intentionally doing something or otherwise negligent, you may be liable to people who walk into your office. Now, concerning employees, as an employer, you have a legal obligation and a duty to provide a safe work environment. And what that means is that because as employers, we have a duty to provide a safe work environment, there are things that we need to do to make sure that the workplace is safe. And that's why the state has issued the guidelines, and that's why the state has asked us to comply with these requirements to minimize that liability. And also, I want to say on this point that at least Cal OSHA has publicly said that the standard that they're going to use in enforcement is a good faith standard. And what that means to me is that instead of being the inspectors looking at this as the obligation that you have, they're going to look at the COVID-19 situation more as if you are trying to do something in good faith. As long as you're in good faith trying to do something to prevent the spread of the virus, then you're going to be in compliance. And that's good news, because if we do something in good faith, we're going to minimize the legal risk and the liability towards our employees and the public in general. Shannon?
Yes, a couple preliminary remarks I wanted to make are, we're dealing with multiple layers of regulation here. We're dealing with federal, state, county, and sometimes even city. So the rule of thumb to apply is to follow the most restrictive law. Some counties are moving at a slower pace. They have more restrictive requirements. So you want to be aware of that. The other is, this is, as we all know, this is an evolving situation. New information's coming out daily. So these orders and guidelines are going to change, and it's important to just stay on top of what is current and check your resources like the state's COVID-19 website. I'd also suggest checking, if you're in Orange County, the Orange County's health agency's website. The CDC is also a good source of information, and just really staying on top of it. And Javier, would you like to start talking about the checklist?
Right, so a couple of things, and Chris, I'm gonna ask you to share on the screen this flyer that has been published by the County of Orange. So this is where we're at. At least in the County of Orange, there are 5 things that the county is asking business owners to do before reopening. So before you reopen, you're gonna do all 5, right? Yes, so number 1, it is to conduct a risk assessment and to establish a protection plan. What does that mean? Well, it essentially means that looking reasonably at the workspace to identify areas where can be or have a risk of infection. And we know that the risk of infection goes up if there are surfaces that are touched or contact, if people are physically too close, or anything that will make it easier for people to get contaminated because they share air. This is an airborne disease, so anything that will keep people away, anything that would avoid the touching of surfaces, and anything that has to do with being clean, those are potential risks that can be minimized by doing an inspection. But part of what the guidance requires from the state of California, and we gave you a copy of the guidance, and this is the guidance, what it looks like for offices. When you read the guidance, one of the requirements of the guidance is to establish a specific site prevention plan. So a COVID-19 prevention plan is something that on paper looks like a lot, but quite frankly, is pretty straightforward. And one of the materials that we have shared is a sample COVID-19 prevention plan. And what is important about this plan is that the number 1 thing that you have to do is to designate the person who's going to be in charge of the plan. So my recommendation is either you as a business owner or somebody that you delegate the authority to should be the master of this plan. And whomever that person is should try to keep in constant communication with the authorities, and this can be on the website, and just checking for new and updated information, because this information changes sometimes on a daily basis, like Shannon said. So once that you have your plan in place, in writing, and you have the master of the plan, then the second step is to train employees on the limit of the spread. Again, what does that mean? Well, it is essentially they suggest having a meeting, of course, not having the meeting in person, but the suggestion is to have employees understand how the virus is spread and how people get contaminated, on the symptoms of the virus, and on measures that the employees can take to prevent the spread of the virus. An important part of this second step is also to give training to employees on self-checking or self-identifying if they have symptoms, and for them to do symptoms checks at home or at work. And Shannon is going to talk more about how to go about that. But when we talk about training, one of the things that I want to share, Chris, if we can switch to the other document about prevention and training of employees, is pretty straightforward, very, very simple. The number 1 thing that we can do all to prevent the spread of the virus is to wash our hands, to hand wash frequently. Now, if you're going to be hand washing frequently in an office setting, that means that the time spent washing hands is compensable time. So there's an issue with making sure that people get compensated for frequent hand washing, and that they're allowed to take those breaks. The second is physical distancing. We have heard it, to try to be at 6 feet apart as much as possible, and do not spend, or try not spending more than 10 minutes close to somebody. And lastly, the wearing of face coverings and masks. Those are things that we can take. So looking at this is from the CDC. The first part of this flyer that is public and is in 10 languages. So it makes sense to have it in more than 1 language if you have workers that English is not their main language. There's information on how the virus spreads, on what people can do, the wearing of face coverings, and lastly, the cleaning and disinfection of surfaces and areas that can be of contamination. So that's step 2. Chris, if we can go back to the 5 points. The third of the 5 points is taking and adopting control measures. This is what the governor has referred to adaptations. And there is on the guidance, the list of specific adaptations for office environments, and Shannon is gonna go over those. So that's the first step. The fourth step on what the county is asking business owners to do before opening is to sanitize and disinfect the workspace and to create a protocol or system to continually disinfect, to continually clean, especially those surfaces that are shared. Items or tools that are shared should be disinfected and cleaned on every use. And lastly, maintaining and keeping physical distancing. And it doesn't say about face coverings, but in the County of Orange, the health officer issued an order which says, and is still in place, that if a person cannot keep 6 feet of distance, he or she is required in the County of Orange to wear a face covering. So right now, as of today, it is a rule by the health officer to wear a face covering whenever you cannot keep 6 distance apart from another person. This last requirement has become, unfortunately, a political issue. I don't know why, but it has, up to the point that the health officer received death threats and she quit on Monday. So my speculation is that the new health officer may do away with this order. So maybe it's not going to be required in the County of Orange. It's just going to be a strong recommendation, but whether it's a strong recommendation or an order from the health officer, the wearing of face coverings, certainly by employees, is a measure that will help minimize the legal risk that employers have on their duty to provide a healthy and safe work environment to their employees. Lastly, the County of Orange has also required, and we have given you a copy of the guides issued by the county in late May, one of the requirements, which is not unique to the County of Orange, is that business owners should make a certification, or in the words of the guidance, an attestation that has to be published near the entrance of the business, where the business owner or operator is certifying that he or she has complied with these 5 steps. And we have a sample of what an attestation kind of looks like. So this is something that you can sign as an operator or business owner and put it near the entrance as required to certify that you have complied with the requirements of the county. Now, I think it makes sense to have one of these, because if there's a health officer driving around doing inspections and they go by your business or office and they see one of these on the door and the business next door doesn't have one of these, guess on which one the inspector is going to walk in, right? So that's why we gave you a sample of what an attestation looks like in compliance with the 5 steps required by the county prior to reopening. And the most important factor, of course, is the implementation of the adaptations or control measures, which Shannon is now going to go over.
Yes, so the guidance breaks down the safety precautions into 3 main categories. The first being the individual control measures and screening, the second, disinfecting and cleaning protocols, and the last is physical distancing guidelines.
Chris, we don't need that. I'm sorry. Yeah, there we go. Better.
Under the individual control measures and screening, the guidance says to implement temperature and/or symptoms screening for all workers at the beginning of their shift, and also other workers or vendors or contractors who come into the premises. So what does that mean? First of all, notice the language, it says and/or. Employers are not required to do both, however they can. You just at least have to do one of those screening measures, whether it's temperature and/or symptoms. What is the temperature screening? Checking whether a person has a fever, which the CDC considers 100.4 degrees Fahrenheit or higher. That temperature screen can be done at home. You can require employees to self-screen themselves at home before they enter the workplace. in that case, you should train your employees how to do that and to check that if they have a fever that's 100.4 degrees or higher. You can also do a temperature screen in the office as well. That is permitted. A symptom screening is basically asking whether they have any of the symptoms of COVID-19 listed by the CDC, including shortness of breath, coughing, sore throat, and you can check the CDC website for all the other symptoms. They can self-screen at home, whether they have any of those symptoms, or you can screen them at work. You can ask them. Some employers have questionnaires that they have employees fill out. So that's a business decision really for you to make on what's best for your office environment, whether you're going to have employees self-screen or do the screenings in the workplace, or potentially both. The next point that the guidance makes is to encourage sick employees to stay home. So obviously, if they're having any symptoms of COVID-19, to tell employees they need to stay home, and better yet, encourage an employee that's sick at all to stay home. It's better safe than sorry. As far as face coverings, Javier did mention it's not required in the guidance, but it says it's strongly recommended that employees that are in the vicinity of others in the workplace are wearing face coverings. And as of today, that order is still in place in Orange County, requiring individuals to wear face coverings if they can't maintain 6 feet of physical distance. The guidance also says to take reasonable measures to remind employees to wear face coverings. I'd suggest you could post a sign, you could do email reminders, verbal reminders. As far as gloves, to consider using or providing gloves to supplement hand washing where it may be helpful. If anyone's doing a screening, if you have an employee who's doing symptoms or temperature screening, they should wear gloves. And then if you have an employee, let's say a receptionist or somebody who's touching a lot of objects that other people touch, it would be a good idea to have them wear gloves as well. Cleaning and disinfecting. Workplaces are required to do frequent cleaning and disinfecting. Those include high traffic areas, so your waiting areas, your lobbies, any break rooms, lunch areas, entrance areas or exits, any frequently touched surfaces, such as doorknobs, restrooms, and hand washing facilities. And you're also required to use EPA approved products. And when if the employee is doing the disinfecting, they have to be provided with gloves when they're doing that. The guidance says to avoid sharing office equipment and supplies to the extent possible. So if you can avoid sharing phones or any other work supplies or equipment. Where it's not possible, then you're required to disinfect either between usage or shifts, whichever is more frequent. So items like fax machines, copiers, printers, telephones, keyboards, staplers, etc. Those are areas that will need to be disinfected when they're being shared. You should also keep your sanitary supplies stocked, like paper towels, soap, and hand sanitizer. And finally, to check the ventilation systems. The guidance says to consider upgrading them to increase outside air. This is not required, but you should at least check that your ventilation system is in working order. And then the last category, physical distancing guidelines. The guidance wants you to implement measures to ensure that there is a physical distance of 6 feet between for workers and clients that you may have in the workplace. So you can do this by using visual cues like floor markings or having signage. You can also do this using physical partitions. I'm sure you've seen the plexiglass some people have used. The guidance also says to look at redesigning or your office space to ensure that there's 6 feet distance. So you may need to move some furniture around. You may need to take out some chairs, set up your conference room and meeting rooms to ensure that there's enough space so that people can maintain 6 feet of distance. And then also consider closing or restricting common areas, like kitchens and break rooms, making sure that you don't have people congregating in those areas. and then discourage employees from congregating in other areas in like the hallways. Avoid having multiple guests waiting in lobby areas, and instead take them to their meeting room or the office place. They also have a couple suggestions, if possible, to establish floor directional hallways, basically having one-way direction hallways so that employees aren't crossing each other, passing by each other. You could do that with floor markings or signs. And if possible, having separate entrance and exit points to avoid people passing again. They suggest installing and using shelves and bulletin boards to do handoffs of items and work production, basically, again, limiting close contact between employees. If you have elevators, you're to limit the number of employees in an elevator and to ensure that they're wearing face coverings in the elevator and post signage on that. As far as the number of people in the office, the guidance says to utilize practices that limit the number when feasible. And they give suggestions like having staggered schedules, having alternating days in the office, or returning employees back to the office in phases. They suggest staggering employee work breaks so that you don't have employees taking their breaks all at the same time. As far as travel, they say to stop non-essential travel and instead conduct distance meetings over the phone or via the internet. And then finally, handshakes, you should require your employees to avoid handshakes and any other greetings that would break the physical distance requirement. We did receive a question in advance of the webinar asking us about the number of people inside an office. And I'll read the question. It says, basically, we're a small office of 9 folks, and for the past 3 months, 4 of us have remained in the office while the other 5 have worked remotely. We're trying to navigate how to bring back the other employees and eventually start seeing clients again. We understand the importance of keeping safe distance and possibly rotating shifts so there aren't too many people in the office. How do we determine a safe number for building occupancy? Okay, so there is no magic bright line number on, there is no requirement based on square footage as far as how many employees you can have in the office. What I would say is this, I mean, the guidance is clear that you need to implement measures to ensure 6 feet physical distance. So you don't want to have employees in the office that are most of the time less than 6 feet within each other. So to the extent that you can redesign your office or move things around so that people, at least when they're primarily working, are maintaining that 6 feet distance, I would think you're okay. If that's not possible, looking at other measures like staggering work schedules or having some employees telework or alternating days, or looking at other methods of reducing the number of people in the office. But again, there is no bright line answer to this one, and it really depends on your office space and your particular situation and business needs. So now we're going to move, unless we have any, Chris, I don't know if we have any questions pending right now.
I think we're good right now. Obviously, anyone that has a specific office reopening question, feel free to send to me in chat box, and I'll make sure to communicate that to Javier and Shannon. But I think we're good right now.
Okay, great. Okay, so now we're going to move into talking about the employment law considerations for reopening, and I'm going to spend some time discussing employment policies that you should review and or update.
Now,
so,
Shannon, sorry to speak over you. Before we move there, I do want to add a couple of comments on the adaptations.
Sure.
Yeah. The question about how many people should I allow in the office is a good one, because in other industries, the guidance do specify a limit on occupancy. Sometimes it's 50%, sometimes it's 25%. It depends, whether it's a fitness center, a bar, a place of worship. So there are different guidelines. For offices, it's more flexible, I think. So I agree with you 100% that anything that we can do to ensure physical distancing and any measures taken to avoid, right, contamination, including the frequency of cleaning, should be good to minimize liability. Another thing that I wanted to say is that visual cues are really, really important. In the building that I'm at right now, when you step to the elevator, there are some clear markings where to stand to wait for the elevator. Inside the elevator, there's squares where to stand inside the elevator, and and there's a covering on the buttons of the floors. I think that's too much, but that's just my opinion. So visual cues are huge. Second, communication. I think this is a time to communicate. I believe that I can speculate that we have all received some unsolicited emails from people saying, hey, if you're coming back, welcome back. This is what you can expect. So anything that we can use to communicate to employees to let them know what to expect in the new workplace or temporary adaptations, anything that we can do to communicate to clients of the temporary adaptations is going to be useful because, for example, I saw one that it was pretty clever. It seems like this business has an app, and I'm sure that there's many apps out there where when you have an appointment, you have to text them to let them know that you're in the parking lot. Then they will text you back and let you know when to come in, so there's no people gathered in the waiting room. Well, that's one area to minimize the risk by ensuring that there's not going to be people in the waiting room, right? So communication is key. And finally, concerning the wearing of face coverings or keeping of physical distancing, my opinion, we just have to make it cool. We have to find a way to get some influencers to make it cool so people do it just because it's cool.
All right. Okay, so back to the employment policies that you should review or update. If you are not already aware, there was a federal legislation that passed April 1st called the Families First Coronavirus Response Act. This legislation applies to all employers with less than 500 employees, which I guess is most of you on this webinar. And it's in effect through December 31st, 2020. And you're required to, if you haven't already done so, you're required to post this, the federal poster, which you can find on the Department of Labor's website. And you need to post it where it's visible to employees. If you have employees that are working remotely, teleworking, then you should email it or mail it to them. And basically this legislation has two components: an emergency paid sick leave component. This is where you have if you have employees that are unable to work or telework because of certain specified reasons. And the reasons include, one, that they're subject to a federal, state, or local quarantine or isolation order related to COVID-19, or if they've been advised by a healthcare provider to self-quarantine due to concerns related to COVID. 3, if they're experiencing COVID symptoms and seeking a medical diagnosis. 4 is if they're caring for an individual who's been subject to the orders that I just described, either a quarantine, governmental quarantine order, or direction by a healthcare provider to quarantine. And then 5th, if they're caring for their child whose school or place of care is unavailable or closed due to COVID reasons. And then finally, there's a catch-all provision where if the employee is experiencing any substantially similar conditions specified by the Department of Labor, the Department of Labor hasn't designated any other conditions, thankfully, so don't need to worry about that right now. So basically, if an employee falls under one of those categories I just mentioned, and you have work available, but they can't do it because of those reasons, then they're entitled to, under this federal legislation, up to 80 hours of paid leave for full-time employees, and for part-time, the average number of hours they work per week for a period of 2 weeks. There are rules on how you calculate that pay and caps depending on what the reason is. Important thing to remember is an employer is eligible to get reimbursement through payroll tax credits. So it should be a wash. The employer should get reimbursed and is eligible for that reimbursement. The second component of this legislation is an expanded FMLA leave. This has to do with if you have employees that, again, you have work available, but they can't do it they can't do it either in office or remotely because they need to care for their son or daughter who's under 18 because the place of care or their school has closed or is unavailable due to COVID reasons. This is 10 weeks of paid leave at 2/3 their rate of pay, capped at $200 a day. And again, this is reimbursed to the employer through payroll tax credits. So it's important to keep these in mind as you're reopening, and especially because we don't know what's happening with the schools and what the reopening of the schools is going to look like, if there's going to be any sort of distance learning component, et cetera. The state also published recently a guidance on family-friendly policies or practices. We included that in the materials. You can take a look at that and peruse it. It's basically the state is recognizing that childcare is going to be a concern for employees. Again, because of the reasons I mentioned with schools. They're suggesting that employers consider some family-friendly policies. Some of the ones that they mention include working from home. I would suggest if you have employees teleworking, that you have a telework policy. Another suggestion is flexible scheduling, offering flexible spending accounts that allow employees to pay for childcare with pre-tax dollars. Making sure they have access to paid sick leave. I mean, that's required under the Families First Coronavirus Response Act. And also there is the state California paid sick leave law that you want to make sure that you're complying with, which essentially provides employees with 3 paid sick days per year. And then they also mentioned guaranteeing that women are not discriminated against because of pregnancy, motherhood, or family responsibilities. It's interesting that they mention that, and I think that's something to watch out for when you're making your employment decisions. Plaintiffs' attorneys may be looking out for those types of cases to bring discrimination claims as we are returning to work and dealing with childcare issues. You should also look at your ADA and FEHA practices. The EEOC and the DFEH have issued some guidance on how to navigate dealing with COVID-19 amidst the pandemic. So normally you can't ask certain questions because they're considered an invasion of privacy. Normally you can't ask, about somebody's medical condition unless under very specific circumstances. Because we're dealing with a pandemic, the EEOC and DFEH has said you can ask employees that are entering the workplace about whether they have COVID-19 symptoms. In fact, you're now required, as we talked about earlier, to screen them or make sure they're self-screening. Be careful not to use it as an opportunity to ask employees about non-COVID related conditions. It's not a time to be asking all your employees to disclose whatever disabilities they have. And any information that you obtain, that information as far as their symptoms or in their temperature readings, that is considered private medical information. So that information needs to be stored in separate confidential files. You can also tell an employee, if an employee is at the workplace and they're displaying any symptoms of COVID-19, whether you think they have COVID-19 or not, but if they have a symptom, you can tell them to go home. That is allowed. If you have an employee who has been diagnosed for COVID-19, keep in mind that that diagnosis is private medical information. What you can do to avoid dealing with the privacy issues as you try to advise employees that have been possibly exposed to quarantine is you can ask them to sign an authorization for you to disclose that they have been diagnosed so that you can assist you in ensuring that other employees are safe. If they don't sign such an authorization, you can just notify your employees that they've been potentially exposed, but you should not disclose the identity of the person who has been diagnosed. And finally, you can require a doctor's note. If someone has been diagnosed with COVID-19, you can require that they, before they return to the workplace, that they provide a doctor's note clearing them to return to work. Work-safe policies, workplace safety policies, you're going to want to look at those. Obviously, we've been talking about with the COVID-19 prevention plan that we gave you a sample. Also keep in mind that all employers are required to have what's called an injury and illness prevention program. The COVID-19 prevention plan is supposed to be in addition to your injury and illness prevention program, which you should already have. If you don't have it, don't worry. You can go to the Cal OSHA's website. We provided that link in the materials. They have a what's called an e-tool where you answer questions and it'll generate a plan for you, and you can add that to your materials, and it's free. So now Javier is gonna talk to us about returning and rehiring employees to the workess.
But before
really
we
quickly.
do,
Yeah, sorry, Javi. I was just going to jump in quick. I do have a question for our panelists, and maybe I could, whoever wants to take this. It reads as follows. I'm sorry if you've already covered this, but in the communal bathrooms in most offices, it would be impossible to maintain 6 feet distancing unless modified to only allow one person at a time. Do you recommend modifying bathrooms for a single person use?
Okay, that's interesting question. I mean, the safer you are, the better. I mean, obviously you could do that, but I don't think you have to do that. There's nothing in the guidance that says you can't have more than one employee in a bathroom. I think the important thing as far as physical distancing is really, my interpretation is, how are employees spending the majority of their time? The majority of their time working, do they have 6 feet of physical distance? If they need to use the restroom and there's another person there, I don't think that's as concerning. Or if they, have to walk out and they walk by someone, I don't think that's as concerning. I think when you're talking about office workspaces, what we're really talking about predominantly are people working at their desks or in some sort of workstation cubicle. And, where is that in relationship to other people? Do they have 6 feet distance? That's my reading of it. How about you, Javier?
well, I agree with you that the guidance talks about making sure that people are not 6 feet or are more than 6 feet apart, and that if they have to be closer, they try to keep it under less than 10 minutes. So that's the requirement. The requirement is like, let's make the adaptations that will ensure that people are at least 6 feet apart, and that if they cannot, they try to minimize it for less than 10 minutes. That's what we have to do to provide a healthy and safe work environment. Now, having said that, landlords are taking it upon themselves to do things like, for example, I went into a restroom where they had visual cues. And it was really interesting because they had multiple places where you can wash your hands, but one has a green thing, and then the other one had a red one that read, let's keep it safe, 6 feet apart. And then the same for the stalls. They have like visual cues, like, green and red. And interestingly, something that caught my eye was that they had a trash can that it was red, and it said, for tissues and papers only. So I was like, what? It's separate from the trash can? So they're trying to treat like the paper as medical waste or something. So I think that's too much, but anything that you can do to prevent the spread of the virus is going to be good.
Right. And as far as bathrooms, and just to keep in mind that that's one of the areas that should be frequently cleaned and disinfected too.
No doubt, no doubt. And interestingly, I heard of a complaint of an employee from a janitorial company that was complaining that the disinfectants used by the cleaning company were not approved by the government. So be mindful that there are some areas of risks that have to do with what disinfectants you actually are using. They have to be approved by the EPA. That there may be some concerns from employees that the employer is not doing enough to keep them safe. And there's a class action lawsuit in Chicago that I believe they had a hearing yesterday on it. And Amazon has been hit with a class action lawsuit. So look, the chances of we getting hit with a class actions are minimal. But now that we know that there are lawsuits out there making the allegation that the employer had to do more, anything that we can do in good faith is going to help keep the attorneys away. And that's how we like it, right? Now, a couple of comments that I have on what Shannon said. Shannon, on the expanded, right? The emergency paid sick leave makes sense. There are essentially 5 reasons why people will get paid sick leave on an emergency basis. I want to say that that's above and beyond, and you said it, this is above and beyond the California paid sick leave. Another thing that I want to make sure that we all take home is that on the FMLA expansion or the medical leave expansion, when the schools are closed or the person taking care of the children is unavailable, childcare is unavailable, that is something that applies to all. You see, the FMLA only applies to employers that have more than 50 employees, but the way the Families First Coronavirus Response Act, or the FFCRA, reads is everybody has to provide this, even if they don't have to provide FMLA. So that's new, but it's temporary until December 31st. And finally, two more things. When somebody tests positive, your suggestion of getting a waiver is huge. I think that's the best way to go about it, because if not, the privacy of the employee has to be maintained. But the next question is, do we as an employer have a duty to let the county know so the county can do the tracing? And the answer is, I don't know. So maybe we just need to recommend for the employee who tested positive for the employee to communicate with the county so the county can do the tracing. But maybe we are, as employers, going to notify the county as well so they can do the tracing, because there's an obligation to close the workplace, to disinfect, and to try to prevent, including tracing. Finally, on the Injury and Illness Prevention Program, or the IIPP, we all have one, but it's supposed to be for known risks. The virus is supposed to be temporary. So at some point, hopefully, this is all gonna go away. So it shouldn't, I wouldn't make it part of the permanent Injury and Illness Prevention Program. And that's why the separate COVID-19 prevention plan is a good idea, just to have it separate, because one day, hopefully, we are not gonna need it anymore. And that was that. Now, switching gears on the employment side of things, there's a couple of areas that we wanna talk about. And one area that is something that the employers face when planning for reopening has to do with who is gonna come back, right? We know that we have a recommendation not to have the same number of people in the office space, to try to keep it to a minimum, or to ensure physical distancing. So if ensuring physical distancing means that we're gonna have less people at the office, who's gonna come back to work? And the point that I wanna make is that when choosing who is going to come back to work, make sure that you use criteria that is non-discriminatory. Because if you use any criteria that is discriminatory, you might find yourself with a potential claim. And what does that mean? Well, I handled a consultation that had to do with an employer that chose to bring some people and allowed other people to work from home. And one of the employees complained that the people who were asked to remain at home were the people who had children that school were closed. And they were saying that you're discriminating against me because I have children. In another case, there was an issue with people who were laid off or furloughed, right? The allegation was that the people who were furloughed were the people who had children in school, because people who have children in school, when their schools are closed, are entitled to receive FFCRA paid emergency sick leave, right? So any factor that you use in deciding who is gonna come back, be mindful that the person cannot make the allegation that you're using one of their characteristics against them when you're bringing them back. Maybe seniority, or some other factor that is neutral that you can use to avoid the allegation that the people who were chosen to come back to work from furlough were discriminatory. Another point in bringing people back to work is whether we have to accommodate for people who don't want to return to work. And the reality is that because there is an expanded unemployment insurance from the federal government, which means that whatever people get in unemployment insurance, the federal government has an additional compensation that is gonna last until the end of July. The concern is that some people don't wanna come back to work when called because they would like to continue collecting that expanded unemployment. So if somebody says, hey, I don't wanna go back because I wanna continue collecting unemployment, I make more money staying at home than going back to work, what do we do with those employees, right? And the answer is, I don't know. But one thing that you can do is to accommodate that and say, if you want to stay home and you don't want to come back to work, we're going to extend your furlough status, and you're going to continue to be furloughed But my recommendation is that you do it in writing, and not only that, that you let them know that if they chose not to come back, and if they voluntarily choose to remain on furlough, the employer may need to hire somebody else to cover this position. So if and when they're willing to come back to work, the job may not be available for them. So that's one option to deal with people that don't want to come back for that reason. Another option that you have is just to let them know that they were offered a return to work, that they refused to return to work, and that you are going to end their employment. This is an employment at will state. It is a valid reason for termination. You send them a final paycheck, and that was that. Of course, that one is more risky. And some employers have decided that they are going to let the EDD know that the employer refused a job, which has consequences for the unemployment insurance. Any of those three that you choose, my suggestion is that you do it in writing so you have a record in case this comes back. But the important one, I think, is when somebody says that they don't want to go back to work because they fear they will be infected with the virus. What do you do then? Well, my suggestion is that you, again, do it in writing and you communicate all the adaptations that were made to ensure a safe work environment, and let them know that you have made an attestation and that you have followed the guidance and that you have taken all of these measures to make sure that they have a safe place to work, and ask them to come back to work. If after communicating the adaptations, they still refuse to come back to work, well, again, we either extend the furlough status with the clarification that the job may not be available when they want to come back, or we end the employment. Those options are available. Of course, I prefer just to continue the furlough status, because the reality is that when somebody's on furlough, you don't have to pay them. It's just that if and when they want to come back to work, the job may or may not be available. If the job is available, no harm, no foul, they come back. If the job is not available, well, sorry, we told you that the job may not be available, because all of this is based on the fact that we are following the guidance, we are taking precautions, and we have adaptations in place. And the last subject on this area of who's going to come back has to do with the obligation of the employer to accommodate people who are at a higher risk of infection, or people who have a medical condition which will put them at a higher risk of infection, or people who actually have a disability that need an accommodation. And the answer to that balancing of interest is that it's a case-by-case analysis, and we have to be very careful to analyze a situation when somebody asks for an accommodation, because if they ask for an accommodation just because, the answer may be that they have to come back to work. If they ask for an accommodation because they have a medical condition, then the interactive process is triggered, and there may be necessary for the employee to provide medical documentation to justify the accommodation. And at the end of the day, after the interactive process, if the accommodation is unreasonable for the business does not have to provide an unreasonable accommodation. Only a reasonable accommodation supported by medical evidence applies to the employee. Of course, there are some people that are on the list of higher risk just because of their age or because they have a chronic condition. In those cases, it depends. Because, you know, for example, we receive a question of that had to do with somebody who said, hey, I am an older person, and because of my older age, I would like to have an accommodation. And the answer, the basic answer is like, well, let's take a step by step. I know of some old people who run marathons, and I know some old people who cannot go up a flight of stairs. So it depends on how strong your lungs are. You may not be at risk just because of your age. So there may be a need to look at the medical documentation that would justify the reasonable accommodation. And if it is reasonable and justified by a medical condition or justified by a disability, then chances are that the interest of an accommodation is going to prevail, and the employer will have to give the accommodation considering the rules under the Americans with Disabilities Act and the California Fair Employment and Housing Act. Shannon, any follow-up comments on that?
Yeah, just a couple comments. I think what this highlights is, and I think a good a good rule of thumb is to try to be flexible. I think, we're in uncharted waters here. How the law is going to treat some of this stuff when the lawsuits come out, and believe me, they will. There are plaintiffs' attorneys that are, at home not able to work because the courts are closed or just starting to reopen. So they're going to be eager, and to try to avoid trouble, if you can be flexible to the extent you can, to try to. And then as far as employees that don't want to come back to work, one thing I wanted to point out: if the employee doesn't want to come back because they have a disability that makes them in the higher risk category, I totally agree with you, Javier. Letting them stay out on leave is great. Keep in mind, though, that when they say, "Oh, okay, I can return now," you may have still a duty to try to accommodate them. The position may no longer be available, but you may have another position that they're qualified for or could be qualified for with some, minimal amount of training. So just be careful. Anytime you're dealing with an employee with a disability or potentially a disability or medical condition, and to just be careful before you make a termination decision. And that's something that you might want to run by an employment attorney. So now we'll talk about wage and hour issues.
Shannon, is it okay if I could jump in here? I have a couple questions from our attendees, and I'll read them in order. The first one is, can a business owner require visitors to the office to wear a face covering? If whoever wants to take that.
I'll take it.
Go for it.
I am 100% for face coverings, 100%. And that's why I'm frustrated by the political pushback. I don't understand it. So if somebody offline can help me understand it, please do. So the question, as I understood it was, can I, as a business owner, ask a customer or client to wear a face covering?
Require the visitors to wear a face covering.
Require it, right. So what I would do if I as a business owner is to engage the person and to let them know, to say, look, as you may be aware, in this county of Orange, it is required by the county to wear a face covering if you cannot keep 6 feet of distance. Indoors, it is hard to keep 6 feet of distance for less than 10 minutes. So I'm going to ask you to please wear a face covering. And like I said, let's just make it cool. Maybe we can have just a bunch of masks available and say, if you don't have one, we can give you one for your convenience and use it while you're here, please do. And if the person says yes, great, no problem. If the person says no, I'm not going to wear it because for whatever reason, then my next step will be to say, I have an obligation as a business owner to provide a safe environment for my workers. And one of the requirements is to ask people to wear face coverings. And you said no. Can you help me keep my people safe? Is there anything I can do to do the transaction? Can I do the transaction for you? To find a way to help the person without the person just going up and down without a face covering. If they say no and they absolutely refuse, I don't know. I will just let them in, and after 10 minutes, kindly ask them to leave, because it's not worth to have a fight over it when health officials are receiving death threats. That's just where we're at. Shannon?
Yeah, so to answer the question, can you require it? Yes, you can. You can require people entering your premises to wear face coverings. You have that right. If you want to tell someone they can't enter because they're not wearing a face covering, you do have that right. Under the OC Health Agency's current order, it does say, unless the person has trouble breathing or has some kind of disability or medical condition that prevents the wearing of the face covering. So I would say to avoid hot water, if they tell you they have some kind of condition that makes it hard for them to wear a face covering, that you don't press the issue. But the bottom line is, it is your right, it is your premises, and you can require that as part of the service you offer.
The second,
and finally, a good point. This is your place of business. If you have the absolute right not to wear a face covering, but not in my business, right? So if they refuse to leave, you can call the sheriff and say that they were trespassing. But that will be an escalation.
Yes. If the next question is if the entire office has been telecommuting thus far, are we able to reopen the office given the California roadmap language? Offices can open, quote, when telework not possible. And OC language, quote, telework strongly encouraged, question mark. Any thoughts about that?
So again, you should follow the most restrictive. So the state says if telework not possible, so I would then say that's what prevails. However, there's no specific guidance or explanation on that. We don't know what Cal OSHA is going to do, or if that's going to, to the extent that that would be enforced. I would say it's good practices to the extent that you can have employees telework to continue to do so, because just for the simple fact that it greatly eliminates the risk of COVID-19 occurring in your workplace. Think about the ramifications if one of your employee does get diagnosed with COVID-19. You're going to have to shut down areas that employee was in and do a thorough cleaning, disinfecting. I mean, there's a lot involved if that does happen. It's not insurmountable, but you might want to weigh that, the costs and benefits of bringing people back if it is possible for them to continue to telework. Javier, do you have any thoughts on it?
Yes, that's a really good question because they seem to be at odds. But from my perspective is what is possible? Well, I can tell you, I know of attorneys that have a law firm and they have a reception person. And most people are working from home because they can connect and do the professional work on a computer. So I asked the attorney, like, why do you have a reception person? And he said, because the packages, I need somebody to pick up packages and mail. Well, it's not possible to pick up packages via Zoom. So in that sense, if it is not possible, you absolutely can bring the person back. If it is possible, the preference is that they do it remotely. But if you have a good computer system and they can access files remotely and all that good cloud stuff, it's easy to implement work from home, but some jobs require physical presence. So it is not possible to have somebody work from home. That's my reading of it. When it's not possible, they have to come back. And that's why all these adaptations and all of these safety precautions. Now, we were going to talk about wage and hour issues, right? Time is of the essence, but I think it's important we talk about that. Shannon?
Sure. Okay, quickly, for hourly employees, you should keep in mind that let's say you have somebody who comes in, they're scheduled for a full day's work, and then let's say you don't have enough work for that full day and you send them home. If they report to work ready and able to work and then you send them home after an hour, there's something called reporting time pay, where an employee has to receive they're entitled to at least half the time that they were scheduled to work. So let's say someone was scheduled for an 8-hour day, they work an hour, you send them home, you would need to pay them additional 3 hours of pay to equal that 4 hours. There's a minimum of 2 hours for reporting time pay and a maximum of no more than 4 hours. For your hourly employees, you also want to make sure that you are paying them for any time they're spending cleaning, doing the hand washing breaks, also symptom screening and temperature check. If you're requiring them to do temperature check, symptom screening at home, that is compensable. You have to pay them for that time. So keep that in mind. We also suggest that you review the classification of any of your salaried employees if you've reduced their pay, reduce their salary, or change their job duties. There are specific requirements as far as how much a salaried exempt employee is supposed to receive. If you have less than 25, if you have 25 or less employees, they need to receive at least $49,920 a year. If you have 26 or more employees, it's $54,080. Basically, the rule is two times the state minimum wage is what the salary must be in order to classify them as exempt. And then if you've changed their job duties such that they're now doing what every other hourly employee does, you likely have a problem meeting that exemption. And you should have that reviewed and consider whether they need to be reclassified to an hourly employee, which means then complying with all the wage and hour requirements for meal breaks, rest periods, and paying them overtime. Lastly, business expense reimbursement under California Labor Code, Section 2802. Employers are required to reimburse employees for all necessary expenditures incurred for performing their work. It's sort of a gray area whether face coverings are reimbursable. Temperature thermometers, I've heard, yes, they are reimbursable. You should, if you're having them do it at home, you should either provide the thermometer or pay the employee for that, reimbursement for that thermometer. These might sound like little things, but these business expense reimbursement issues can become bigger issues. There's something called a Private Attorney General Act claim that an employee can make on behalf of, for themselves and behalf of others. It's similar to class action, but has less stringent requirements. And those penalties can really add up. And a business expense reimbursement claim, an employee can also seek to recover attorney fees, which can be a lot larger than the amount they're actually seeking. So just be mindful of if you're requiring face coverings or temperatures checks at home, just make sure that I would say err on the side of caution. And if you're not providing those things, consider reimbursing them.
I have a couple of points. First, if we're doing symptom checks, for example, taking temperature at the work site, somebody shows up and they have a fever and they go home, I think that show up pay applies in those cases when they showed up. And also consider about the face coverings. If you ask them to wear any face covering whatsoever, you may or may not have to reimburse. But if you ask them to work specific type or specific color, this may become a uniform, and it may become a uniform issue also. So to avoid the uniform claim or to avoid the for the benefit of the employer claim, I think it's just better to pay it off, to pay the face coverings for employees. It's safer.
Agree.
Well, perfect. I just want to do a very heartfelt thank you to Shannon Wolf and Javier Carbone for doing, this is a part 3 of 3 webinars. You guys have been terrific. Really appreciate it. I want to thank the attendees for coming and our sponsor, Jador on Del Mar. And these 3 webinars are available through the Downtown Business Association website at www.scdba.org. And if you have any more questions, please contact Shannon and Javier for all your employment needs right here in San Clemente. Thank you so much, and we appreciate it. Thank you, guys.
Thank you.
Thank you.